In this installment, Brian Parker is being interviewed by Heather Cross, discussing Construction Contracts 101.
Brian, if I'm an owner and I'm going to be hiring a construction company to embark on a construction project, what sort of contract do I need?
Well, the contract between the owner and the contractor can take a couple different forms, and it really depends on what the arrangement's going to be with the contractor. What I mean by that is, what are the services or work that the contractor is going to be carrying out, and how will the contractor be compensated? If you're using the classic design, bid, build delivery model, where the owner engages an architect or an engineer to design the project, and then calls for contractors to bid on the project based on the drawings, there are two main forms of contract used: the fixed price contract and the costs plus contract. A fixed price contract is a contract where the contractor agrees to build the project as laid out in the plans for a fixed price. The Canadian Construction Documents Committee, the CCDC, has a standard fixed price contract form. This is the CCDC2 contract. A cost plus contract is a contract where the contractor will build the project as set out in the plans, but there isn't a fixed price for the work. Instead, the owner agrees to pay the contractor all of the contractor's costs of constructing the project, such as amounts paid to subcontractors, the costs of setting up the site, etc. And tacked onto all those costs is a fee, often a percentage of the total cost of the work, although it can be broken up in different ways. The standard form for a cost plus contract is the CCDC3. Another way you can set things up is a construction management arrangement. That's where the contractor is brought on before the plans are completed and works with the architect or engineer in designing the project and obtaining bids for different aspects of the work. The benefit of this arrangement is that it can introduce practical aspects of constructing the project in the design phase, which can increase efficiencies and avoid problems down the road. There are CCDC forms for this as well, namely the CCDC 5A and the CCDC 5B. The 5A is a true construction management agreement, where the construction manager does not hire the subs and is really just a manager acting on behalf of the owner. The 5B is where the construction manager not only helps with the pre-construction design of the project, but also acts as general contractor for carrying out the construction, including entering into the contracts with the subcontractors.
So, Brian, it sounds like there's a CCDC form of contract for the common types of arrangements between owners and trades. Is an owner or developer okay to pull one of those forms of contracts off the shelf and proceed with the project?
Not exactly. The CCDC forms are useful in that they provide an industry standard starting point for the shape of these arrangements. But from an owner's point of view, the CCDC forms need to be adjusted to address specific concerns. For example, if you're dealing with a costs plus arrangement, the definition of the costs of the work is critical, as the scope of that definition is going to determine the amount the owner is ultimately going to have to pay. That's just one example. There are many others. Often, we see parties starting with a CCDC form of contract, but then amending the form by attaching a set of supplementary conditions. Since this approach to negotiating construction contracts has been around for some time now, many of the supplementary conditions have become quote-unquote standard in the industry. And when they represent a fair and balanced approach, we find that the parties settle the contract relatively quickly.
That was Brian Parker in conversation with Heather Cross on the topic of Construction Contracts 101. If you would like to learn more, contact Brian on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.